Hi, everybody. It's Electra Yao, artist visa lawyer, here to talk about all things related to the O-1 visa, to the artist visa. And today I want to talk about something that is pretty prevalent in those who are on their visa journey, which is the discussion or the understanding of what visa is better for you and what visa is better for your situation. Is the O-1 visa better for you, or is the H1B visa better for you? Which one is better for you? Now, to illustrate this or to illustrate my point, I want to talk about, um, I want to give you a little story about a consultation that I've been having. This person has booked multiple consultations with our firm. And I just want to tell you about what happened to this person. So, this person was on an H1B, did an H1B transfer, really interested in the O1. Guess what happened? She got laid off, she got fired. This means that well, let's back up. The H1B is tied to an employer. You can have concurrent H1Bs, meaning you can have multiple H1Bs for different employers, but the H1B essentially is traditionally and typically used for one employer, meaning you are an H1B for Yale Law Group, you're stuck with Yale Law Group for the next 3 years. That's just how it works. The O1, conversely, does not work in the same way. You can treat the O1 as an H1B, but most people do not because of the benefit of being able to work for multiple employers without needing to file an amendment. This is why, in my opinion, the O1 is better than the H1B. Number one, you can have multiple employers, which is what this consultation was seeking. This person was seeking to be able to work freely and to be able to run her own company. So open up a company, run a company, hire people, et cetera, et cetera. This person was looking to be free. So having the ability to work with multiple people on different sorts of projects without necessarily being tied to the employer. Now, for those of you who are not familiar with what being tied to an employer means, this means that you're stuck with that person. You're stuck with that company. That company controls you. Meaning, if that company wants to withdraw your petition, so call USAS or send USAS a letter and withdraw the petition, they can absolutely do so. Why? Because they control the petition. They are the petitioner. In the O1 world, you do have a petitioner, but it's not necessarily your employer. It could be your employer, but it's traditionally not structured in that way. It is structured in a way that you have an agent that is petitioning for you, that is filing for you, and then you have multiple, we'll call them employers. But usually in a consultation, I call them people, places, and things. Oh, you can't hear me? Maybe it's because my phone was, can you hear me now? Can you hear me now, Kenshin? What I was saying is the reason why I don't call them employers, I don't call them jobs in the O1 world, because they can essentially be people. So individuals that you work with, they can be projects, so that projects that you're working on, they can be different types of professional future endeavors that don't necessarily have to be tied to a singular employer, if that makes sense. Whereas in the H1B world, you are tied to a singular employer, and that singular employer controls your O1. They control whether or not you can be in H1 status. So whether or not you're in status is going to depend on the employer. Now, conversely, with the O1, it doesn't work that way. You can, like I said, structure it in the H1B manner, but not everybody wants to do it that way because the legal burden is higher, right? You have more to prove. O1 petitions are very large. H1B petitions are not so large. So you have more to prove. It's more abstract. No sound available. Let me try to sign on and sign back on. Sorry, everybody. So essentially, as I was saying, sorry guys, I had to sign out of Instagram. But what I was saying is the evidentiary burden and the evidentiary requirements for the O1 are much more burdensome, are much higher than that of an H1B. So that is something that is really important to realize, because you're going to be spending a lot of money to work on an O1 petition versus an H1B petition where it's a lottery base. You can enter or you cannot enter. or get accepted or not be accepted. So I'm signing on to Instagram again. I'm on Instagram. Please let me know if you can hear me. If you can't hear me on Instagram, hop over to Facebook or hop over to TikTok, so that you can hear me talk about O1s and why I think that they're much better than your H1Bs. So the reason why I started this is because I wanted to talk to you about this consultation. Who is very interested in the O1, very interested in the O1, but unfortunately got laid off. So she is now in her 60-day grace period. And like I said yesterday, those who are in their 60-day grace period are being issued NTA, so notice to appear in immigration court. This is actually really important because this switches the jurisdiction between USCIS and the EUIR, which is immigration court. Now, when you're in removal proceedings, that's something that is very serious, right? You're in deportation proceedings to be removed from the United States. You want to be in the USCIS jurisdiction where it's more transactional as opposed to litigation with the government. So why is the O1 better than the H1B? Because if she had been on her O1 and she had gotten laid off, then she wouldn't need to be scrambling to go back home. Because on an O1, if you get fired or if you get laid off, your duty is to work. Your duty is to continue to work. Now, in the arts world, that has many different meanings. That has many different definitions. Working can be something like starting your own company. Working can be something like drafting your own marketing plan to improve your artistic profile. There are many different definitions and interpretations of what work is because traditionally artists do not have the same definition of work as somebody who is a traditional worker, like somebody who's on an H1B. So this allows you to do more things. This also allows for damage control. So if you are ever in that situation in the H1B world, you're going to be fired, you're going to be in your 60-day grace period, and then the employer has to inform USCIS that you are no longer employed by them. In the O1 world, because of the artistic nature of the work that you're doing, you're not going to be stuck with one person. Think of it like, what if you were an actor? As an actor, you are not necessarily going to work for the same production studio or the same theater company for the next 3 years. That would be incredibly limiting professionally. There are different theater companies that have different focuses. Here in New York, you have street theater, theater for the New City, which is downtown. You have experimental theater, which is La Mama ETC, which is also downtown. You've got cabaret type theater. So if you were limited to the type of theater that you can perform, you would be extremely limited, number one. And number two, extremely frustrated because you'd be stuck with a theater company and and the theater company also knows that they own you, they control you. I mean, it sucks. It is what it is. That's how the law was drafted. But that is the biggest difference that people see and that I see in the H1B and in the O1. The ability to not be beholden to a singular employer. Now, what does that mean in real life, right? Like, forget the law, forget that you can have multiple employers in the O1 world. But this basically means that you can change employers. You can expand your creativity and expand your career, right? Obviously, within the bounds of what the law is asking of us, within the bounds of what was argued within the petition. You can not be scared. That is like the worst feeling in the world, like being scared that you could get fired. And if you're fired, what does that mean? That means you're uprooted from your life. That means that you have to think about what are you going to do for your kids. If you have kids, you're going to think about your lease. This client or this potential client who has gotten laid off and I can't do her O1 because she has no staff. This person was thinking about her lease, was thinking about her cat, was thinking about her friends and family, thinking about her whole life that was in the US. That is gone. That's it. Fired. Gone. In the O1 world, it's not like that. If you get fired from a theater company and you filed an agent-based petition, guess what? Your job is to work. Now, theater is very vast. You could do, like I said, experimental theater. You could do one woman show or one man show. You could do street theater and literally perform in the street theater. You could do theater in the round. You could do Shakespeare. You can do so much stuff to not trigger your 60-day grace period. I don't think that a lot of people understand how revolutionary this is because we take freedom for granted. We take the ability to be the master or the mistress of our own destiny for granted. Those of us who work with O1s, those of us who have clients are on O1s, we take for granted this beautiful freedom that they have, the beautiful freedom that is given only through the O1. Even if you were an entrepreneur, even if you were to open your own company, you would still be beholden to your company. If that company is not making money, well, guess what? You're going to have a really tough time for the extension. There's no requirement for your business that you create on your O1 to make money. Of course, you must earn income because we must prove to the government that you are not going on government benefits, et cetera, et cetera. But you could do that in a number of different ways. Why? Because of the nature of the industry. We are right now, when we submit proof of payment, we submit Venmo screenshots, PayPal screenshots, copies of handwritten receipts because sometimes people get paid in cash. There's a number of different ways to prove that people are making money. And in the O1 world, I don't need to prove a minimum, right? I don't need to prove that you're making a prevailing wage like I do in the H1B world, right? Obviously, we cannot violate federal law and state law with regards to how much somebody is earning, but there's no requirement that an actor or a visual artist or a designer or a filmmaker make, I don't know, $55,000 a year. That requirement just not doesn't exist in the open world. And when you're free from always thinking about money, because if you think about how the trajectory of art is in the real world, not everybody did things for money, right? Especially visual artists, you only make money if you sell your work. And at that, you're only making 50% of that sale. So in the arts world, you are not always motivated by money, right? I mean, of course, everybody wants to earn money, everybody wants to make income, but the analysis of the success of an artist versus the analysis of the success of, for example, a doctor or a lawyer is not necessarily going to be an analysis that is tied completely to economics, which is why you don't have an economic component as a requirement for arts-based visas. Incredibly liberating, really incredibly liberating. This means you're not beholden to a theater company or a production company or an agency to pay you a minimum amount of salary. You should get paid what you're worth, right? You should get paid, obviously, a salary that is not violating federal and state law, but you should get paid what you're worth. But that is independent of an immigration analysis. Blows my mind how much freedom one has with the O1. And you can be on the O1 in perpetuity, literally forever. You can continue to extend your O1, whereas in the H1B world, you have a limit. And you better hope that the employer at the end of your 6-year term is going to file not an extension, sorry, a perm application, which will allow you to extend your H1B. Again, green card beholden to the employer. O1 world, no. O1 world, you depend on you, which is actually quite scary for those of you who are not entrepreneurial, but it depends on you. Your petition or the strength of your EB1A is going to depend on you, what you did in your career, how much you worked, who you worked with, what are the things that you did to elevate yourself from the other artists. Completely dependent on you. Requires an entrepreneurial muscle to be able to execute, but at least it's you, right? At least you don't have to depend on external people. At least you have the freedom of knowing, okay, I did what I needed to do, or, oh, I didn't do what I needed to do. I need to continue working. So this freedom that we take for granted that does not necessarily exist with other visa types. I want you to think about this. I want you to think about this when you're signing a lease, when you're bringing your kid to school, when you're going to buy bread at the store. Think about the freedom that you have to be able to move from one job or from one future engagement, they're called in the O1 world, to another future engagement. Obviously, it must be in the field that was argued within the petition. I can't file you as an actor and then you're like, hey, I want to be a makeup artist, unless that was part of the petition discussion. But you guys understand what I'm trying to say. So I want you to think about that. And then I think you owe it to yourself to engage in this exercise to see who do you want to be in 5 years? Kind of like that question that they ask you in job interviews, like, where do you see yourself in 5 years? Ask yourself that. And I think that is going to guide you in the decision you make in terms of whether or not you pursue the O-1 versus the H1B. Now, in this discussion, I'm not by any means saying don't do the H1B. I'm just telling you what are some pluses of the O-1. And these pluses are all directly linked to freedom. And that is why a lot of people want to work in the US. This person that I consulted with was devastated to go back because she wanted to live her career here in the US, right? For all the faults that may exist here or may not exist here, it is still very fertile ground for people to develop and work on their careers. So think about this freedom and think about why freedom is better than being locked up, right? What are the things that you can do as a free person? Whereas, what are the things that you cannot do when you're beholden to an employer? And that's why I think the O-1 is better than the H1B, purely for the philosophical and also real life practical experience of being able to live your artistry and your career in not absolute freedom, because that doesn't exist, but in as much freedom as the federal regulations will allow, as a policy memorandum will allow, as case law will allow. And it's pretty extensive. Um, so I hope that this was helpful. I got a question yesterday, and I wasn't able to answer it late yesterday after the live about the use of AI. There's no law that is preventing a private individual from using AI. There is no law that is preventing you from using AI as a private person. I am a licensed attorney in New York State. There are rules that prevent me from using AI. And therefore, we do not use AI because I do not believe that AI's knowledge output trumps my decade plus years of experience and knowledge of trends. And even if I wanted to use it, because of the rules of law, must get my client's permission to be able to utilize AI in the work that we do. Now, I'm not sure if that person was asking me like a strategy question, like, is it good strategy to use AI? I'm going to bring back my example of the doctor. If you trust a doctor that uses AI to diagnose you, good, then you probably have your answer. I personally don't. I personally want a doctor who's going to engage with me, who's going to want to talk to me, and who's going to want to try to figure out what my symptoms are based on whatever medical practices exist to be able to assess and diagnose a patient. There's no law that prevents you as a private individual. So that comment that I made was not directed to private individuals, but it was for licensed attorneys in New York, which is me. Strategy wise, I don't think it's the best strategy. And that person who I was talking to you guys about earlier, who was on the H1B, that person did not work with an attorney. So again, if we're talking about strategy, had that person consulted with a licensed, experienced attorney at the beginning of her immigration journey, she probably would not be in this situation because she probably would have been advised accordingly on the best ways to structure her H1B time to be able to transition into the O-1. So you want to make sure that there's strategy, which is very unique and personal to the individual, to the attorney. And then there's rules and laws that we must follow, right? The rules and laws that I must follow as an attorney are not going to be the same for a private individual. And those who know our firm know that we follow the rules of ethics absolutely, right? There's nothing that we do that is contrary to the rules of ethics, including this discussion on AI. So yeah, I hope that it's clear to the person who had that question about AI. If you want to use AI and you feel comfortable doing that, I personally think immigration petitions are high stakes legal matters, and if you feel comfortable with that strategy, you do what you want. Probably should talk to a licensed, experienced attorney before making those types of decisions, but you can't really cut corners, right? When it comes to high stakes situations like your life, your livelihood, and your ability to make money, it always puzzles me why an individual would try to cut corners and try to save money. you're putting a price tag on your life, where I hope you believe that your life is priceless. I believe my life is priceless. I believe the work of everyone's life is priceless, and should be acted in according to that. But if that's what that individual chooses to do with her his or her petition, nothing I can do about it. So hopefully this was helpful. Hopefully I was able to really hone in the importance of this liberty that you have, this professional liberty that is so important to the United States, and so important to the development of an artist, that you cannot get in any other visa type. Even the O-1A. So tech founders, people who work in the sciences and athletics, they do not have the same, or they do not enjoy the same liberties as somebody in the arts world. So important things to consider when you're mapping out your immigration journey, and you're mapping out who you want to be in the United States. Hopefully this was helpful, and I will see everybody tomorrow. Sorry about the hiccup with the sound earlier. It was resolved, and those of you who stayed to listen, thank you for staying. Bye, everybody.